Hello, good afternoon. This is Tracy B from the Divorce Solutionist. Hi. Um, Sorry about last week for those of you who were looking for the live. Excuse me, my shirt. Last week I had technical difficulties, so didn't happen. Um, Things happen. I tried to minimize that, but sometimes it's unavoidable. Anyway, I'm here today. And I decided today to do something I haven't done in a while, which is, and when I started doing Thick of It Thursdays, I used to go through the groups that I either or administrate or administer, and get fact patterns or real life situations from them. Of course, leaving their names out of it. Or I would go on to different other groups like Reddit and other forums that I'm in where I would get cases or situations that were real, and I would come here and discuss them. So I'm going to revert back to that for today. I mean, I like that idea. I mean, I like to mix it up. Nothing about me is homogenous. Everything I do is usually varied and kind of mixed up. So with that being said, um, I'm going to start off with, I might do two fact patterns today, but I wanted to do definitely one of them that caught my attention today. And it's pretty long, actually. So, and I chose this one because there was a lot of stuff going on here. Um, but wait a minute, is this the one? No, that's not the one. Bear with me one second. I'm sorry. I've had such a crazy day today that, okay, here we go. Okay. So my ex-husband and I have a 2-year-old, and we don't get along by any means. We have to use a co-parenting app to communicate so that it can be monitored by my request for him harassing me. The other woman moved in the day I moved out, and we've never been cordial due to multiple events. She's proved she's a nut job. That alone, that has a lot going on in there. And this is a woman. This is obviously a woman who I think the divorce it's pending. But as she mentioned, they have a 2-year-old, 2.5-year-old child. They have a paramour on the husband's behalf who's involved. And then they have communication issues. So there's a lot of issues. There's a lot of layers of stuff going on in this particular fact pattern, which is why I chose it. Um, but let me continue. While going through the divorce, some of my clothes went missing. My jewelry, lingerie, camera, bike. I would come home and the bed I slept in would have dirty shoe prints on it. And our old engagement of maternity photos would be taped on the ceiling above my bed. That's a little weird. Okay, that's a whole nother. Since the divorce, it's been over a year now. She will periodically wear the clothes that went missing when I go to pick my kid up. That is really strange. I just laugh it off. But she also is insistent that my daughter calls her mom. She will bring her out instead of my ex and say, Mama loves you. I'll see you soon. And then ask her to kiss her on the lips. When it first happened, I told my ex it wasn't appropriate, and technically, she's brainwashing our child by telling her to call her mom. I checked with my therapist and attorney, and both agreed. Until a child is old enough to choose what they want to call them, they should be using first names only. Well, I'm old school, so they shouldn't even be using first name. They should say Miss, then first name. But that's me. My ex just called me crazy and told me to shut up. I talked to my daughter about it, and she doesn't call her mom when she's with me. She'll say at daddy and so's house. So she knows. But today, after a particularly bad argument with my ex, when I picked my daughter up, she made a point to make my daughter kiss her on the lips. My daughter was already walking away towards me, and she called her back to get a kiss from mommy. I know she wants a reaction from me, but I won't engage with her at all. But I'm worried that she's confusing my child and it's unsafe for her to kiss my daughter on the lips. What should I do? Okay, this is way too much going on. First of all, I don't automatically suggest people run to court to get modifications, contempt, enforcement, whatever, especially when there's already a lot of conflict and toxicity in divorces or custody battles. This is one of those cases that needs to be before a judge again, because this other woman is doing way too much, and the ex or soon to be ex is doing way not enough, because there are way too many lines being crossed, way too many boundaries being pushed here. Absolutely not. And from a GAL's perspective, I would actually either bring my own motion to the court, because GALs can file motions on their client's behalf, which is the child, and let the judge know that boundaries, limits, parameters all need to be put in place as far as this other woman is concerned. First of all, she doesn't make clear that this is a wife or just a paramour. Not that it makes a difference, with her being disrespectful and just completely violating a lot of rules, but it does make a difference as far as how the judge may actually decide to rule on this. Because say this woman here, they don't work out, and another woman comes along and she has the same, issues, more boundaries. A judge may look at that as, okay, this is not just the women, this is the ex-husband or the soon-to-be ex-husband's issue. He needs to um, he needs to do something way more than constantly and continuously getting with women who think it's okay to cross boundaries when it comes to co-parenting. And as opposed to if it's his wife, it's still a violation. It's still disrespectful. It's still rude. It's still a lot of other things. But from a court's perspective, um, sometimes they will look at a wife and expect different from a wife than they do a paramour or a girlfriend or whatever. And either way, though, this should definitely be brought back to court, because I think that was number one. Number two, no child should be forced to call anybody dad or mom unless it's dad or mom. No one should be forcing a 2.5-year-old to be calling them mom or dad. It just does not work. That's not how it works. If they get to an age and they decide to call their parents, significant other, dad or mom, or even mommy Jane or daddy Mike, that's their choice. That's their choice. And not even the biological parents can interfere with that or should interfere with that. But that's their choice. But no one should be forcing. And this mom should definitely bring that to the court's attention. What will a judge do? He will reprimand dad. He will reprimand dad. He will order dad to get her to refrain from this. He may order counseling, therapy, whatever, but he will reprimand dad. And if it continues to happen, it may wind up being a decrease in time, supervised visits, therapeutic visits. I mean, I'm getting extreme, but it can. I mean, it depends on how egregious it gets. If he's not setting any boundaries now, he's probably the kind of person that won't. And so she'll escalate. She might escalate. It might just get worse. I mean, the baby's only 2.5. So if this particular other woman remains the significant other of dad, she actually might get worse with her antics. So if it were me, I would definitely go to court and have a judge issue a specific order telling him, dad, what the other, because he can't direct the other woman, because the other woman is not a party to the action. So he can't issue orders that include the other woman. But he can tell dad what is not to take place within his home when the child is there or not. he can do that. He's every right to do that, and he will. As to the personal belongings he took that were inappropriate, I mean, she decided to let that go. It depends on, the value of that stuff. I probably would have too. However, um, what happens when you do that is they think that they can continue to do that. It's a control thing. I'm going to be honest with you, and I hate to sound sexist, but with men, it's about control. They'll take things, they'll come in when they know their wife or ex-wife isn't home and start taking things while the divorce is pending. Or there'll be a divorce judgment that says what they can have, what they can take, and they'll take more than what they're supposed to. I see it done all the time. I mean, women do it too, but for some reason, husbands do that a lot. But what's creepy is that he gave clothes to the other woman and she wears them. Like, who does that? I mean, there's not much she could do about that legally, but I certainly would have make sure that if he's done that once and things were fine, then okay. But if he's done that once and then twice, I would actually include that in the contempt enforcement violation motion as well, because a lot of time that snowballs. And I see it all the time in other situations, other scenarios where the husbands continue to do that. One uh, uh, Facebook post, I'm in a ton of groups. One group I was in, one lady said they've been divorced for like years, and he still comes by and takes what he wants out of the house, out of the marital home, without her permission when she's not home. I mean, years later. And that's what I mean. Like that, it happens. It happens a lot. So I would try to nip that in the bud. I would bring that to the court's attention only if I have a motion for other stuff. I wouldn't file a motion just for that, but I would certainly include everything about those kind of things in the motion that's already being filed. And in this particular case, I don't know where this person is, but a motion for contempt for custody maybe may have to be brought in a different venue than a motion for contempt for the divorce decree. I don't know. That depends on how the courts are structured. But so I say that to say she might have had to, in this particular scenario, she might have had to file two separate motions or one. It depends on how the court, how your state court's procedures are set up. Um, what else came up in here that I had an issue with? The other thing is, okay, so I had a long discussion with another client of mine about using co-parenting apps. And I'm a big advocate for co-parenting apps because they can be very convenient, and it helps. I mean, one of them, I think it's OFW, has a tone meter in it. I think is it OFW? No, I think it's Talking Parents, has a tone meter on it. So it helps you to check your tone when you're actually responding to a antagonizing message from your ex or your soon to be ex. So, but I'm a big advocate of co-parenting apps because it actually helps to track discussions and, like I said, check the tone and minimize harassment and conflict and a lot of that stuff. I mean, they're not 100%, so no one should go into it thinking that they are, but they're very helpful. They're very helpful, and I bring that up now because some people automatically think, oh, co-parenting app is involved, that means it's all bad. It's not all bad. It's a good thing. Even sometimes when there is no conflict, sometimes just using a co-parenting app, sometimes it just helps to keep confusion or not confusion, things that actually escalate down to a minimum. And another reason why I brought up the co-parenting app thing is because she still communicates with him at pickup and drop offs. And I mean, that's inevitable. But for me, what would be more aligned with using a co-parenting app would be a pickup and drop off at a neutral location. Why? Because of things like what this other woman has done. Oh, come back and give mommy a kiss, and showing that she's wearing a clothes. Not that they wouldn't happen at pick up and drop off at neutral locations, but neutral locations sort of diffuses things, and it sort of de-armors some people. They feel more powerful when they're at their home. They feel more comfortable. And I'm assuming the other woman lives with the this particular woman's ex. So they feel a lot of times it takes away power when you're on neutral grounds. And this other woman seems like she's more antagonistic and more bold and more power. She feels more powerful and courageous at the home. So sometimes having a neutral pickup and drop off location is best to keep some of this what's happening here down to a minimum as well. Also, it helps to leave her home. Include in the order that pickup and drop offs at a neutral location, this other woman or any other woman should not accompany dad when the pickup and drop offs happen. And that's something the judge would order, especially when there's been a history of women like this doing stuff like that, making the little girl call her mommy, and just doing things that really, really irk the nerve of mom here. And so when I file my modification petition or motion, I would certainly ask for what I already discussed. No calling mom. If the taking of the property, if she wants to bring that up, and I would definitely ask for a neutral location for pickup and drop off, and that the other woman is to not be present at the time, because we don't need any conflict, unneeded, unnecessary, extra conflict just because this other woman is present at the pickup and drop off. So the kissing on the lips, that is completely inappropriate. Absolutely not. Absolutely not. And that is also something that should definitely be brought to the judges. We don't know where, who, what. This woman should not be kissing her 2-year-old. It's not even, I can't even say her 2-year-old stepchild, because it's not. It's just her paramour or significant other's daughter. She should not, she's a stranger. She's a stranger. In the age, not even because of COVID, even before COVID, way too many germs. And if she's kissing her, who else is she kissing? We don't know. Who else has she kissed? Absolutely not. So this mom needs to run to court to file a modification petition asking for all of these things. As far as dad calling mom names and disparaging, the reality is, and I get this question asked a lot. Oh, what can I do? He's so disrespectful to me. He's always saying mean things or bad things to me when we're in person, blah, blah. We can, I think most of my parenting plans or settlement agreements that I've done, particularly if I was the GAL and I did it, I would include that neither parent is to say disparaging things about the other in front of the child or in front of someone else who would communicate that to the child. But the problem with that is that no one's going to be in the homes of the respective parties to police them. No one's going to be the extra set of eyes and ears and come into court and confirm that this is being said. Of course, when there's kids who are older, like teenagers, who can say, yes, this is what he says, or this is what she says when the other parent's not around, that's different. But so she can ask for that. I don't know if that clause or that particular provision is in their agreement. If it's not, then I would certainly include it. I mean, it can't hurt. It can't hurt to have that, because in the event that anyone actually does ever witness either party doing that, then there's a reason for, again, a contempt or violation motion or petition to be brought. I mean, again, so modification and violation petition, if you notice, I use those terms interchangeably, and it depends on the circumstances of the case. I sometimes I will say violation because I want it to sting. Sometimes it's just contempt. I meant to say modification/violation. I usually do both. If I'm asking for a contempt or violation, contempt/violation is the same thing. I usually ask for a modification as well, because I want to give the judge some other consequences as a result, once he finds or she finds that there has been contempt or a violation of a court order. I want to give the judge some ideas of how we should penalize the violating party. And so that's why I seek a modification. I usually seek a modification in a violation or contempt proceeding. I usually add that. And in her particular case, I might not ask for a modification for anything specific in this particular fact pattern. I would ask for, I would ask that if they have a custody agreement, that it would be revised to add those things that I mentioned. To some people, it might seem superfluous to do it because the judge is probably already going to add those things. But I would actually still ask for a modification of the current custody order, custody agreement, custody decision. And I would include those provisions that I just discussed in the last few minutes. Again, another reason why I always do more instead of less is because I'm always creating a record. In the event that my client decided to appeal, they would have a clear record of what the issues are that need to be appealed. So if you just seek a violation or contempt and you don't ask for modification, and there's a reason why maybe the judge should have modified or you could have modified and it wasn't brought up, then you can't appeal that. If you brought it up and the judge either ignored it or deviated from what the law or the procedure is for that particular jurisdiction, then you preserve that record. You can bring that up in the appeal. A lot of people don't appeal because it's very time consuming and it's very expensive, but you always want to do that. It's just like trial. When you go to a divorce lawyer, custody lawyer, and you're thinking that you're not going to go to trial, so they're always preparing for settlement. No, you still want to prepare for trial. It depends. It depends. Again, it's not cut and dry. For me, the more issues are involved, and the more far apart the parties are with respect to issues, and the more the issues are complicated, they're not clear, I would prepare it for trial. And then if it settles, it settles, but I would still put it on the trial track, so to speak. And so I do that with cases too, as far as the appeal track. I like to handle cases as if, in the event the party, my client, decides to appeal it, that they can. So I don't see any questions. No, I don't see any questions. So I am going to end it there. I just want to remind people that I'm here live every Thursday at 4 p.m. Eastern Standard Time. And I do go through, as I mentioned, actual cases or situations that I pick up from several sources. And sometimes I just choose a topic and I discuss the topic. And so I go back and forth with respect to that. I also want to remind people that I do have two groups, the Divorce Glow Up and Pro Se Custody and Divorce. My Pro Se Custody and Divorce group is particularly for pro se litigants who are looking for guidance with their case. It's more geared toward people who need help, with drafting documents or reviewing documents or things like that. I mean, not that represented parties don't need that, but with represented parties, they usually have a lawyer. And if they want somebody to review a document or draft a document, it's usually extra. It's usually just to double check or to follow up to make sure their lawyer is doing it accurately or competently or professionally, or whatever you want to call it. But so either one of those groups on Facebook. So I also on Instagram at The Divorce Solutionist. My website is thedivorcesolutionist.com. I do offer free 15-minute consultations where I can discuss with you how my services can help you. I just want to be clear that I don't handle divorce and custody cases. I don't represent, I do uncontested divorces, but I don't go to court, and not anymore, on divorce or custody cases. I can refer you if you're in my area. because I do have tons of colleagues who still do that. But what I do is I coach, consult, and I offer unbundled services. So I help people who need a second set of eyes, a second set of ears, or who need someone to hold their hands, while they're going through the case. Because my perspective on a case, any case that's divorce or custody, is always going to be a little different because of my background. I've been practiced. I was a family law attorney for years. I was a mediator, a guardian ad litem. I taught classes. I blog. I um, do a little public speaking. I used to do a lot of pro bono work. I still do a lot of pro bono work. But so with all those hats and all those different roles, I feel like what I've learned and how I developed is much more helpful and useful to parties who are going through divorce or custody in this capacity. And this is why I created the Divorce Solutionist. So um, if you want a second set of eyes, a second perspective, a different perspective, particularly if you want to package your case to strategically strategically uh, prevail, then I am your girl. For me, my focus is strategy. I'm very analytical. I'm very detailed. I have a tendency to see the whole picture when a lot of, as a lawyer, it was hard for me to do that because everything was chop chop. Now I get to sit back and take my time and analyze everything, every detail, and come up with a plan of action um, to help you get to the results you want more so. And it's a lot less expensive than working with just the lawyer. Um, so anyway, that is my spin. That's my take. Feel free to like my page here on Facebook at the Divorce Solutionist. It's my business page on Facebook or Instagram or LinkedIn or Twitter. It's all the same handle. Or visit me on my website. Feel free to email me at divorcecoachesq@gmail if you have a question, or DM me here on Facebook as well if you have a question. But it's best to take advantage of the 15-minute free consultation that I offer, and because that way I can discuss some things with you that's hard to discuss in an email or a DM. Anyway, thank you so much for watching. I look forward to meeting and discussing and working with each and every one of you. Until then, ciao.